Everybody. So I'm here with my friend and attorney, Andy George. Andy George works for Kozloff Stoudt, and I don't want to try to describe exactly what he does, but he's a real estate attorney, and I believe he's also a solicitor on some local township boards, if I'm not mistaken.
That's correct. I represent boroughs, township zoning hearing boards, and sewer authorities. So that's what I call my night job.
And during the day, tell everybody what you specialize in.
Yeah, during the day, as you said, I do practice a lot of real estate law, and I also am heavily involved in estate planning and estate administration, meaning drafting estate planning documents like wills and powers of attorney, and then administering the estates and helping executors get through that, administration process.
And that's a pretty complicated process. And for anybody that doesn't know, Andy actually helped me and my wife redraft our wills. It was a pretty quick and painless process. Don't want to say that there wasn't a little bit of paperwork involved, but we certainly felt a lot better after we were done with you than we did before, because we didn't know what we didn't know.
Hey, that's always the goal.
Yeah. Yeah. And, it's funny because when you get married and you're young, you're not thinking about death. You're not thinking about, one spouse leaving assets to the other. But it really is something that should be in place sooner rather than later, because there's unforeseen illness, there's accidents. And in the case that we're going to talk about today, we're going to talk about how, when you help a couple set up a will, and then down the road, things don't work out as according to plan, and now those two parties are going in separate directions because of a divorce. How does that will kind of get untangled?
Right. So the will is one issue, and powers of attorney are another issue. And the issues kind of stack up on top of each other. There's a lot of them in a situation like that. And I can tell you that in a divorce action, estate planning documents and amending them or creating new ones is probably at the low end of somebody's priority list, because as you're going through that process, through the division of property and possible custody issues, support matters, determining where everyone's going to live, those kind of hit the high spot on the priority list. Right. And estate planning is a little bit lower if it makes the list at all. But it is very important to think about either during that divorce process or after the divorce is finalized. So when we talk about estate planning, we normally talk about three documents. One is a will, and the other two are powers of attorney. And the first type of power of attorney is a financial power of attorney, which deals with giving somebody the authority and the power to engage in your personal transactions if you were unable to do that. So it gives someone the authority to be able to sign checks and pay bills and potentially sign a deed for real estate, to be able to communicate on behalf of somebody else. And then the other power of attorney is a medical power of attorney, which gives somebody else the authority to be able to make medical decisions for you if you're unable to. So two very important documents that are affected by a divorce. And in Pennsylvania, the law says that when a divorce complaint is filed, the filing of that complaint automatically revokes a spouse's appointment in those documents. So
say that again.
So the filing of a divorce complaint, that means the start of the divorce action with the official paperwork being filed with the court, automatically revokes a spouse's appointment in a power of attorney. So that could lead to a couple of things. One is, so if your spouse, soon to be ex-spouse, is named and you don't have an alternate person named, then that power of attorney is not effective because there's nobody appointed to act for you. And then the other potential issue is maybe the person you appointed as the alternate is your soon to be ex-spouse's sibling, for example.
Right.
So you might not want that. Maybe you do want that, but
Right.
the potential is there that you don't want that. So those are the issues associated with powers of attorney and divorce matters. The question that you asked was about the will. So how does a divorce affect a will? That's a little more involved. So in order for a spouse to be automatically considered removed from a will, as a beneficiary or as a executor, person in charge of handling the estate, in order for your spouse to be removed, it takes more than just the filing of a divorce complaint. It also requires that grounds for the divorce be established. And that could mean a number of different things, but basically that time frame isn't met until somewhere down the road after the divorce is filed. It just means that maybe there's a 90-day window and then both spouses agree and file paperwork in the divorce, or potentially maybe it's a year down the road after the divorce complaint's filed and the parties are living separate and apart. I don't practice divorces anymore.
Sure. Yeah.
It's been a long time since I thought about that, but definitely consultation with divorce counsel would be needed in tandem with whoever is doing the estate planning work for the individual.
It definitely, you raise a lot of points that a lot of people probably don't even think about. Just like you had mentioned, hey, the power of attorney goes away the minute that the divorce complaint is filed, and that the will doesn't. So I'm automatically thinking, unfortunately, when people get divorced, it's usually not a pleasant time, and there's a lot of revenge and vindication involved, and so I could see how not only could you shoot yourself in the foot if your power of attorney isn't designed correctly, but also if you forget that there's a will, or you don't revise that will, and 10 years later something happens to you, you could end up theoretically leaving stuff to people that you didn't intend to leave it to. Is that correct?
That is correct. So the sooner the better to handle these documents is advisable. You want to eliminate any gray areas, one.
Yeah.
And then unintended consequences are certainly something that nobody wants. And I've seen that in my experience numerous times, unfortunately.
Yeah.
But and also you want to just make sure that your documents are in order, because you don't want to cost your family members time and expense and aggravation later that could have been avoided by something that might be a simple change.
So, I had an attorney on. I actually had a divorce attorney on the other week. His name's Nick Capitano. Nice guy.
I know that.
And we had a good conversation about people getting married. Nobody ever gets married with the intentions of getting divorced, but everybody should have a will with the intention of passing away, right? So the question then becomes, when everybody knows that death is inevitable, but divorce is not, and that divorce ends up happening, what advice would you give for folks that are going through a divorce and maybe using a divorce attorney who might specialize in that part of their life that they're readjusting, but then also needing someone like yourself who can advocate for them long-term after their life has been reorganized to make sure that that piece of the puzzle is now correct as well?
Yeah, I think my best advice to them is to get the advice that's needed. And maybe their divorce attorney does do estate planning work. I mean, there are a number of good lawyers who do both. But if not, if the divorce lawyer does not do that type of work, then ask your divorce attorney who they would refer you to, and then they can work in tandem in making sure that the plan is carried out, because there are a lot of things inside of the divorce action that could affect what the person can or cannot do inside of the will, or with possibly other assets like IRAs or 401ks or annuities or life insurance. The list goes on and on, because some of those things, if not all of them, are wrapped up in the divorce action itself. So there might be limitations depending on what the divorce agreement is or what the divorce judge decides.
Right.
Yeah.
So the law around when you can change the will after the divorce action is filed is actually a protectionary clause to make sure that somebody doesn't go out and quickly change where they would want those assets to go while the divorce is still being negotiated. Is that right?
Right. There is an element of I'm hesitant to get into the legislative intent of why that law's there, but
Gotcha.
I think you're exactly right, and that's probably why that's there.
Yeah.
Yeah.
Well, it's always good to have, solid information from somebody that can lay it out in layman's terms. And I think I told you this when Jocelyn and I came to see you. We had been given the name of another attorney. And quite frankly, just to be honest, it was while I was going through my divorce. And the amount of work that he was asking us to do just to prepare the information that he needed to come up with our will. I remembered when you had done my first will, and I was like, this isn't really the way Andy did it. So my point is, you made the process so simple for us. And it was, I don't want to say it was really fill in the blank or multiple choice, but that's kind of how it felt. As opposed to the attorney that we had originally talked to, it seemed very labor intensive. So kind of an unintended plug for you is that you made the process easy enough for us that it was almost a no-brainer not to redo them. And so, going forward after that, I advocate for every client that I have at settlement, married or not, you guys need a will. You guys have one of the biggest assets of your life tied up together right now. And regardless of how you take title, or who's on the loan or who makes what, if one of you passes away, you want to know that the other person knows what your intentions are.
Yeah, 100% right. And you guys were great to work with and easy to work with. And obviously you're great to work with professionally as well. I've worked with you a number of times, and that is an intended plug for you.
Oh, thank you.
Yeah,
I appreciate
it.
But
my goal is always to make life easy for the client. So if I can do the heavy lifting and put the documents together for you, that's what I do. And it's a give and take. I mean, I do need information from the client, but I have done this long enough where I know the information I know what information is needed, and I can put together sufficient documents for the client.
Right. And I would imagine too, that in the case of a divorce where there's a will involved, it gets, perpetually stickier the more assets are involved and the more moving parts that are involved. If you have somebody that simply has, a 401k and a house that's tied up with a mortgage, you're really only waiting to decide whether or not the attorney needs to divide equity and how much of the 401k needs to be split up.
Sure.
Which is pretty simple, right? It's
Right.
when you get into, multiple properties or, a ton of assets or, some type of weird investment that they put together when they were, happily married, that things get a little crazier for you.
I'm sorry. I'm on my phone and I got a call. But what I heard is that the more complex the assets, the more complex the estate planning process could be. And that's absolutely right.
Yeah. But at the end of the day, regardless of how the relationship ends up, I guess the moral of the story is having a will is better than having no will.
For whatever reason, Andy, I lost audio. Sorry about that. It's some sort of interference, but
that's okay.
The last thing that I'll mention with the will and the effect that a divorce has, you also want to make sure that the individuals that you appoint inside of the will are the people that you want, because a divorce has an effect on your life so significantly that it might affect who those individuals are that are named in the will. So the people that are listed of great importance are the executor, the person in charge of handling the estate administration. Normally you appoint a spouse and then an alternate person. So you want to make sure that's who you want it to be. And then also, if you have potentially minor children, you probably have some sort of trust set up, mechanism inside of your will to shelter money until they were to reach maybe certain ages. So you want to make sure that your trustee is the person that you want. And then also your guardian and of course, you can't eliminate your ex-spouse from being the guardian, because your ex-spouse is a natural guardian and would be the first in line to be able to handle those child rearing duties. But you want to make sure that your alternate person, your alternate guardian, is named, because if something were to happen to both you and your ex, you want to make sure that person is who you want it to be.
Right. So
and
are
I
we back
still
online?
can't hear you.
Oh, you can't? That's so weird. Well, I'll wrap it up and just let everybody know that we're going to put a plug out for Kozloff Stoudt, and we appreciate Andy coming on and giving us some knowledge. And if you guys don't have a will set up, go ahead and get in touch with Andy in his office. They can make it super simple for you. God forbid you ever go through a divorce. We don't ever want anybody to do that. But if you do, now you know what you have to do to finalize those plans. So, Andy, good seeing you, my friend. Okay. All right. We'll talk to you.